that is a drunk person. That is an intoxicated person. When you start to get into the 0.2 something level, you're talking about a person who may not remember all of the events of the evening before. And that brings us to our question of, was she blacked out? Cameras are shut down in court as John O'Keefe's niece and nephew testify to their uncle's rocky relationship with murder suspect Karen Reed. Plus, in a shocking twist, Treadmill dad Christopher Gregor declines to testify in his own defense as his trial for the murder of his 6-year-old son comes to a close. And 30 days after it began and some 70 witnesses later, an Idaho jury has decided the fate of Doomsday prophet Chad Daybell. All this and more this week on Courtroom Confidential. All right, it's been a hell of a week, folks. Lots of updates, a couple of verdicts, much to cover. Let's jump right in. First, after a full day of testimony on Tuesday, there were no more court proceedings for the rest of the week in the murder trial of Boston woman Karen Reed, who is charged in the death of her police officer boyfriend, John O'Keefe. On Tuesday, Bryan Higgins concluded his testimony. Higgins testified that if he had seen O'Keefe on the side of the road when he left, he would have done anything to help him. Higgins also testified to feeling embarrassed by betraying his friendship with O'Keefe by flirting with Reed. Interestingly, Alan Jackson, Reed's lead defense attorney, who had begun the cross-examination of Higgins, was not in court on Tuesday, and cross was concluded instead by David Yannetti. O'Keefe's teenage niece and nephew, who he took custody of after their parents died, also took the stand on Tuesday. While the minors testified, cameras were shut down and live reporting of the testimony was prohibited. Later reports detailed how the children described yelling and heated arguments between O'Keefe and Reed, which became more frequent in the weeks leading up to O'Keefe's death. The night O'Keefe died, his niece was home alone and remembered being awakened by Reed at 4:30 a.m. She said Reed shook her, left, and came back and told her to call O'Keefe. She was just pacing down the hallway, asking what could have happened, the niece testified. She said, maybe I did something, later adding, maybe a snowplow hit him. Jurors also heard testimony regarding blood test results from the hospital where Reed was evaluated and O'Keefe's body was discovered. At 9 a.m., several hours after the discovery of the body, her blood alcohol content was somewhere between 0.078% and 0.083%, right around the legal limit for intoxication in Massachusetts. Investigators, however, placed her peak blood alcohol level between 0.135 and 0.292 at 12:45 a.m. earlier that morning, based on a police report suggesting when she had her last drink. Testimony is set to resume on Monday. So what's happening here? Well, we don't have the benefit of actually having seen the teens testify in court. And so we're getting a lot of our information from mixed reports online and from media outlets. But I think their testimony is important for a couple of reasons. First, again, they highlight Reed's reaction to him not coming home that morning. And I don't think enough has been made of this, quite frankly. If she was simply in a fight with him, and I think evidence of that is going to come out, I do not believe that her first conclusion would be when she wakes up and he's not there, that maybe I hit him. I don't even think it would be maybe he's hurt somewhere. Don't you believe that the more reasonable response to having a fight with someone that you're in a dating relationship with, you wake up in the morning, early in the morning, 4:30, we're not talking 9 a.m., 10 a.m., 4:30 in the morning, they are not home. Isn't a reasonable belief might be that they're just sleeping it off somewhere? You left them at a house where they were going to have an after party. Maybe they had a little too much to drink and they just decided to stay. Maybe they didn't want to come home to you after this big fight. But it's curious to me that her first conclusion she jumps to is that he must be hurt somehow. And I'm just asking people to think about that. Think about that reaction. what does that reaction say? To me, that speaks of someone who has a reason to believe he might be hurt. And if you're making that conclusion, if that's where your brain is going, then to me, that is someone who might know that in fact he could be hurt because they may be involved. And I get it. A lot of people are going to say, well, you're making a lot of jumps to conclusions here. And that's fine. That's what this is all about, is just kind of trying to read the evidence and see where it leads you. But again, I don't think enough has been made over her reaction being, he's hurt, we need to go find him because he might be in trouble. Unless you believe for some reason you have information in your head that in fact he might be in trouble. The second reason why I think that the two teens who testified here are important is that we're starting to at least begin to see proof from the Commonwealth of an actual motive here. And that has been dramatically lacking, I think, in this case so far. I think if you take the Commonwealth's case at its very best and you say, okay, we believe that Karen Reed dropped him off, and we even go as far as to believe that she hit him with her vehicle, where is the intent? Where's the motive here? Where's the reason why she would hit him and leave him there? Without that, you've got a major problem with criminal intent in this case. Without that, I think you have a person who could easily say, it was an accident, or I didn't realize he was hurt that bad, or, you know what, I thought he bumped into my vehicle, but I made nothing of it on my way home, and it was only until 4:30 in the morning that I actually started to put the pieces together and thought something very tragic may have happened. But with this testimony of the children, are we starting to see the curtain get pulled back on what was actually in her mind and how she felt about this man in the days and moments leading up to his death? That's where it could actually be important. And if the prosecution wants to actually prove this case, I think they're going to have to show the jury more of that. And then we got into the blood alcohol level, the BAC. I will tell you, I did many DUIs in my time as a prosecutor. That's where they start you out in the office. They just throw you into misdemeanors, and it's DUI after DUI. A BAC of 0.13 to 0.29, and that's a wide range. I'm surprised they can't pin it down to a smaller degree of error there. But anywhere between that, 0.13 and 0.29 is huge. That is a drunk person. That is an intoxicated person. When you start to get into the 0.2 something level, you're talking about a person who may not remember all of the events of the evening before. And that brings us to our question of, was she blacked out? Was she so drunk that she's really not remembering what happened? And does that start to more reasonably explain her reactions the next day? Does a person with a 0.29 come home, fall asleep, wake up, realize that their boyfriend is not there, and start to go, oh, wait a minute. In my foggy, drug-addled memory, I'm starting to remember we had a fight. I'm starting to remember I drove him to their house. I'm starting to remember I got angry at him and my vehicle hit him and I drove off and said, screw him, let him deal with it. Is that a reasonable interpretation of what we're starting to learn about her level of intoxication? And she's just now realizing what happened, or was too drunk to know what happened, and she's trying to piece together why he's not home. In either case, I don't think her level of intoxication is something that's small as an issue. I think it's something that may play a bigger role in this case than we had first realized. But what do you guys think? You guys are the experts. Is this case already over in your mind? Do you still have plenty of questions? Was the needle moved at all this week or not? Let us know in the comments. All right, moving on. The trial of Christopher Gregor, a New Jersey father charged with murder in connection to the 2021 death of his 6-year-old son, Corey, may soon have a verdict. In a surprising turn of events, Gregor chose not to testify as previously expected before resting his case on Tuesday. Instead, jurors heard only from renowned forensic pathologist Dr. Michael Baldwin, who told the jury that the 6-year-old Corey died of natural causes, most likely complications from pneumonia. This testimony squarely countered that of the state's expert witness, who testified that Corey's death was a homicide and tied his injuries to a pattern of physical abuse. During Wednesday's closing arguments, Gregor's defense attorney told the jury that while difficult to watch, the Treadmill video simply showed a frustrated father, but was not the cause of Corey's death, who died several days later. Meanwhile, prosecutors countered that the Treadmill video was in fact central to understanding the systematic abuse that led to Corey's death, concluding, "Everything you need and want to know is captured on this video." If convicted of murder, Gregor faces 30 years without the possibility of parole and up to life in prison. All right, well, what's happening here? I cannot say this clearly enough. I do not care what any defense attorney says about that video. No jury who watched that video is letting this man walk out the courtroom a free man. I just think that's the way it works. I don't think good-hearted people could sit through watching the abuse that took place on that video and think to themselves, on a kind of sleight of hand by the defense in this case, I'm going to say that even though this man was obviously abusive towards his son, I don't know if his abuse actually led to the very premature death of this young man. That, to me, is just how jurors' minds work. You can give them the law all day long. A lot of this just comes down to how they're feeling about it. And that's why I'm even more surprised that he didn't take the stand. We've talked about this before, but under normal circumstances, it is never a good idea for the defendant to take the stand. There's numerous reasons for that. How somebody performs under cross-examination, how somebody just performs in public speaking, how likable they are. If they tell even the smallest bit of exaggeration, how that can be exploited by the prosecution on cross-examination. All of these things mean that as a defendant, you have to knock it out of the park and nearly perfect performance on testimony if you want to do anything to help your own case out. But this case is not a normal case because Christopher Gregor needed to do something to humanize himself to the jury. That video is inhuman. The conduct of the person on that video towards that child is not human. He needed to show the jurors another side of himself if he wanted to save his skin at all in this case. And I think he missed an opportunity. If nothing else, get up there and squeeze out some tears and tell the jurors how sad you are to have lost your son. How much it troubles you to see your own conduct played back for you in that video. But to sit there and rest upon your rights to not testify, it is your right. And that should be respected. But this was an opportunity to actually show the jurors the person that they might convict for this crime, and he didn't take advantage of that. But at the end of this day, I still do believe this case has some issues. No case is a slam dunk, and this one certainly isn't. And in a word, that is because of causation. Causation is drawing the line, connecting the dots between the conduct of the defendant and the actual death here. The conduct of the defendant in this case is egregious. It's horrible to watch. And it's beyond that video. We know of other instances. But were they able to connect the dots to say that's what caused the death? And they talked about systematic abuse and how he was suffering at the hands of this man in other ways. But when you've got an expert like Michael Baldwin saying, no, this boy died of very unfortunate circumstances that had to do with pneumonia, but more importantly, had nothing to do with the defendant. That's a problem. But when the only testimony from the defendant is coming from recorded statements that he made to police where he's trying to place blame at the feet of the mother in this case. And the only other testimony is his actions captured in that video. I think the jurors wanted to hear from him, and he needed to provide them for a reason. Because here's the thing. Juries need both a legal reason and, sometimes more importantly, a moral reason to acquit someone. You can give them the law and talk about causation and talk about criminal mindset and burdens of proof and everything you want all day long, but you also have to give them a moral reason to acquit someone when you're talking about the death of a child, when you're talking about a person captured on video torturing that child. And I don't think that was provided to the jury in this case. But what do you guys think? As always, you are the 13th juror. Deliberations continue as of this recording. Tell me what you think. Do you think this is a conviction all day long and it's just a matter of time? Let us know in the comments. All right, moving on. After 30 days of trial and 70 witnesses called, an Idaho jury has found Doomsday prophet Chad Daybell guilty on all charges. Daybell was charged with 3 counts of first-degree murder in the deaths of his former wife, Tammy Daybell, and the children of his recent wife. That would be Joshua, J.J. Vallow, and Tylee Ryan. Conspiracy to commit murder in the deaths of J.J. and Tylee, as well as 2 counts of insurance fraud in the death of Tammy Daybell. In closing arguments on Wednesday, prosecutors told jurors, quote, 3 dead bodies, and for what? Money, power, and sex. That's what the defendant cared about. Daybell's defense attorney, John Pryor, countered there simply was not enough evidence to conclusively tie Daybell to the deaths, or even to prove that his wife, Tammy Daybell, was killed instead of dying from natural causes. However, the jury had no trouble arriving at their verdict, taking just under 12 hours to convict Daybell of all counts. Last year, the children's mother and Daybell's new wife, Lori Vallow Daybell, received a life sentence without parole for the killings. The prosecution called more than 60 witnesses, and the defense called 11, including 2 of his 5 adult children. Chad Daybell did not testify in his own defense. All right, well, what's happening here? The prosecution in this case was thorough, well thought out, and straightforward. That is exactly what you want out of a prosecution team. That is exactly what you want out of a prosecution case. You do not need to be fancy. You do not need to be flashy. You need to be just the facts, ma'am. Straightforward, clear, deliberate, easy to follow. And I think that they did that in spades in this case. The only thing I was thinking and could imagine that would have given the jurors pause in this case is the death of Tammy Daybell. And that again comes back to that question we were talking about earlier of causation. Remember that it was only after her body was exhumed and a proper autopsy was performed that the cause of death was determined to be a homicide. Before that, it was not suspected that foul play played any role in her death. That is not a small problem, folks. That is a major problem for the prosecution to have explained in this case as to why now this woman that everybody thought died of natural causes, why now are we saying that it's a homicide? Is it just because you found these other dead bodies and now you want to pin something else on him and you're taking another look at everything? Partially, yeah. But you needed to explain as to why no one discovered this beforehand. And also the conduct that he had in reaction to it that was testified to by his children. I thought that was the weaker part of the prosecution case. Obviously, the jury didn't have much of a problem with it. But I really do believe that this case was one that was won at jury selection. And what do I mean by that? This was a death-qualified jury. This was a jury that is going to lean more conservative, lean more pro-prosecution. They had to answer that question, each and every one of them, that if they felt that the case had been proven to them and the aggravating circumstances, would they be able to vote for death? And every single one of the jurors who sits on this jury has said yes to that. That is a very pro-prosecution jury. But it's something else. The death penalty looms over this case like a cloud. when you are being asked questions about the death penalty in jury selection, you can be sure that your way of approaching that as a juror is going to be a little different. It's going to be viewed through a little bit of a tinted lens. And I'm not saying that every single case that's a death penalty case with a death qualified jury is an automatic guilty verdict, but it is hard to argue that that did not have an effect on these jurors. And so again, wonderful job by the prosecution, straightforward, easy to understand, but they were playing for the home team to some extent with a jury that is already demonstrated that they are interested in the prosecution's view of justice. Remember too, though, that a guilty verdict in this case does not end. We are now moving swiftly into the penalty phase of this case. And buckle up. This is where things have a whole new set of rules. This is where you start to hear about all of the damage that was caused to people's lives in this case, where you start to hear about the victims and how their families have been affected, and revisit some of the other awful things that this case has left in its wake beyond what may have been admissible evidence. The rules are a little bit different. And so be prepared to hear some really awful stuff, and then some very powerful arguments to hear a prosecutor stand up and say that you should give this man the greatest penalty that we have in this country and put him to death. What do you guys think? Do you think this same jury can hold Daybell not only responsible for these murders, but then make him answer for it by giving him the death penalty? Please let us know in the comments. All right, before we jump into the cases making headlines this week, did you know that Courtroom Confidential is now also a podcast? We are. Please check us out on Apple Podcasts, Spotify, Amazon Music, or wherever you get your podcasts. Please make sure to subscribe, share our podcast with your friends. We truly appreciate all the support that we are getting from this growing Courtroom Confidential community. Thank you again. Also making headlines this week, in a closed-door hearing on Thursday, Bryan Kohberger's defense and prosecution argued on a motion that would allow defense investigators to review the prosecution's DNA technique, known as investigative genetic genealogy, or IgG, and unseal parts of the record. Kohberger, the man charged with the 2022 murder of 4 University of Idaho students, is fighting to ensure jurors are not presented with DNA evidence that prosecutors say links him to the crime. Months after Kohberger's arrest, prosecutors acknowledged that IgG evidence had initially led investigators to Kohberger. Prosecutors have argued that they shouldn't have to turn over the IgG evidence because it was not used to obtain any warrants and will not be presented at trial. We'll see about that. Kohberger's team has argued that the defense needs to see all the DNA evidence in the case to understand how and when police began to focus on Kohberger as a suspect and to better prepare their defense. A ruling has yet to be issued. A San Diego jury found TikTok star Ali Abulaban guilty on 2 counts of first-degree murder on Wednesday. 32-year-old Abulaban, went by Gin Kid on social media, was charged with the 2021 shootings of Anna Abulaban and Rayburn Cardenas Barone. The defense was hopeful the jury could have found him guilty of second-degree murder after Abulaban testified on his own behalf, explaining that he was in a distraught mindset at the time of the shootings. The jury was not persuaded by the testimony, which at times was aggressive, self-serving, and narcissistic, quickly finding him guilty of all counts and special circumstances. His sentencing date is set for June 28th. He is facing life in prison without parole. Manhattan prosecutors told a judge Wednesday they are evaluating more claims of sexual misconduct made against Harvey Weinstein and could potentially seek a new indictment against him before his scheduled trial on rape and sexual assault charges is set to begin. During Wednesday's court hearing, the DA said that additional people have come forward with assault claims, and prosecutors are currently assessing which fall under the statute of limitations. In a letter submitted last week, prosecutors urged the judge to order Weinstein's attorney, Arthur Aidala, to stop making public statements meant to intimidate and attack witnesses. The next hearing date is set for July 9th. The retrial on the rape charge is tentatively scheduled for some time after Labor Day. A New Mexico judge denied Alec Baldwin's bid to dismiss his case last Friday, which means the actor is set to stand trial on a charge of involuntary manslaughter in the 2021 killing of Rust cinematographer Helena Hutchins. During a hearing held on May 17th, Baldwin's attorneys argued that the case should be tossed because prosecutors failed to present critical evidence during a grand jury proceeding in January that resulted in Baldwin's indictment on the manslaughter charge. The on-set armorer, Hannah Gutierrez-Reed, was convicted in March of involuntary manslaughter for the shooting. She is currently serving the maximum 18-month sentence. Baldwin's trial is expected to begin in July. And finally, reaching way back into the archives, David Berkowitz, the notorious New York son of Sam serial killer who murdered at least 6 people in the 1970s, was denied parole on Tuesday during his 12th appearance before the board. Berkowitz's deadly spree began in July of 1976 when he was 23 years old. In the months that followed, Berkowitz continued to kill and terrorize New Yorkers, more often than not targeting long-haired women sitting in parked cars. In taunting notes to police and journalists, Berkowitz called himself Son of Sam, claiming he'd been called to kill by demons who had often sent him messages. The murders prompted the New York Police Department to create a 200-officer task force with the sole aim of hunting down the killer. Berkowitz was finally arrested in August of 1977. All right, before we get to what's on the docket for next week, I have some fun news to share. CrimeCon is this weekend in Nashville, and I will be there. So if you see me walking around, checking stuff out, please make sure to say hi. I am always grateful for all of your support. The love from this growing community has been absolutely mind-blowing. And in fact, this week we received some amazing comments we would like to give a special shout out to. First, to Gen X Granny and Lulu Loves Radiohead for the incredibly kind words that they left on YouTube, and to My Girl Birdie for the amazing review left on Apple Podcast Reviews. Keep them coming, folks. As I said, if you haven't already, please subscribe. Make sure to like this episode. Leave us a comment. We love those comments. Keep them coming. We always highly appreciate your feedback. On the docket for next week, Michelle Troconis is set to be sentenced Friday, May 31st for her guilty verdict of conspiracy to commit murder and related charges connected to the disappearance of New Canaan mom Jennifer Farber-Dulos. Jennifer was last seen 5 years ago on May 24th, 2019, dropping off her kids at school. She was reported missing that evening and an investigation was started. Troconis is the one-time girlfriend of Jennifer's estranged husband, Fotis Dulos, who was charged with Jennifer's murder before he took his own life in January of 2020. In March, a jury found Troconis guilty of 6 charges related to the murder. Colorado dentist James Craig, who is accused of murdering his wife by poisoning her protein shakes, is set to appear in court on Wednesday, June 5th. You may recall on April 10th, prosecutors filed a motion to add a 3rd count against Craig, alleging that Craig asked a fellow inmate to plant evidence in exchange for free dental work. Earlier this month, Craig's defense argued that the inmate is unreliable and it violates Craig's due process rights. However, the judge ruled that the prosecution established probable cause and met their burden of proof. Sarah Boone, the Florida woman accused of zipping up her boyfriend inside a suitcase in an alleged game of hide and seek and then leaving him trapped inside until he died, will be back in court on June 7th for a status hearing. Boone was originally scheduled to be on trial right around this time. However, multiple attorney changes have delayed the start date. Boone is currently being represented by, get this, her 8th attorney. All right, folks, that is it for us this week. If you missed last week's episode, you can watch it right here. I'm your host, Josh Ritter. You can find me on social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I'll see you next week for another episode of Courtroom Confidential.